Okay. So thanks everyone for joining us today. This is a really important matter as we'll be talking about today. The Senate is doing a cross-country tour across Canada on Bill C-69. It's an important piece of environmental legislation that undoes some of the major rollbacks that were made by the previous government. It is coming to Vancouver on April 8th, and so we're really encouraging people to come out and have their say and tell the Senate why this bill is important for Canada. So in this presentation, I'm just going to really briefly remind us why we're here. I'm sure most of you on the webinar are familiar with the 2012 rollbacks, but I think it's really important to just remember the context, remember, the situation that we're in now and what led us to being here. And then I'll talk about the promise that was made by the current government to restore lost protections. I'll talk about Bill C-69 and how it strives to achieve those promises, some of the good things, some of the not so good things, and then some of the pushback that's coming out of industry, especially the oil patch. And then finally, what you can do to be engaged in this Senate process. And then my co-panelist, Hugh Benavides, is going to go into more detail about the Senate process and how you can be involved. So Canada's environmental laws are broken. In 2012, at the request of the oil and gas industry to quote unquote streamline environmental approvals, the previous government gutted a number of Canada's oldest and most important environmental laws. So the government replaced the Canadian Environmental Assessment Act that had been around since 1995 with a much weaker Canadian Environmental Assessment Act 2012, CA 2012, which canceled thousands of assessments, going from a few thousand assessments a year to a couple dozen. It shuts out the public from environmental reviews and hands more power to the industry-captured National Energy Board to rubber stamp major pipeline projects and other major oil projects. The 2012 rollbacks also gutted our Fisheries Act and removed legal protections from over 99% of Canada's lakes and rivers through a number of amendments to the Navigation Protection Act. And these were all of these amendments were made at the request of the oil and gas industry, who wanted, quote unquote, to streamline regulatory approvals. There was a considerable amount of pushback from the public, and quite happily in the 2015 election, the environmental laws became an election issue. Canadians fought back against these changes and we won. Stronger environmental laws were prominent on the platforms of 3 of the 4 main national parties, including the current government. And so when the Trudeau government was elected, the Prime Minister immediately mandated 6 cabinet ministers with strengthening key environmental laws. So the mandates were to review Canada's environmental assessment processes and introduce new fair processes to restore public trust, to modernize the National Energy Board, and then to restore the protections that were lost under the Navigation Protection Act, or the formerly called Navigable Waters Protection Act, and the Fisheries Act, and in both statutes to introduce modern safeguards. And in every mandate letter that the Prime Minister sent, he said that it is time for a renewed nation-to-nation relationship with Indigenous peoples. So that's the basis of Bill C-69. These were the commitments that were made that have led us to this point. So in 2018, Bill C-69 was tabled. I'll note at the outset that the bill doesn't address the Fisheries Act. The Fisheries Act amendments are coming through a different bill, Bill C-68. It's been getting a little bit less flack in the media, so we're focusing on Bill C-69, which does 3 things. It introduces a new Impact Assessment Act to replace CA 2012. It introduces a new Canadian Energy Regulator Act to replace the National Energy Board and the National Energy Board Act, and then it makes some improvements to the Navigable Waters Act, renaming it the Canadian Navigable Waters Act. So just in really broad strokes, the new Impact Assessment Act introduces a number of improvements to the way federal assessments are done in Canada. Probably most importantly, it shifts from a narrow environmental assessment approach that only looks at the biophysical environmental effects of projects to a broader impact assessment approach that requires all assessments to consider not just the environment, but the health, social, and economic effects of projects on communities and on Canadians. It also seeks to identify the gendered impacts of natural resource development and find means to avoid disproportionate impacts on women and people with other identity factors, and ensure that everybody has equal access to the benefits that come from development, the jobs, the economic development, the economic benefits that trickle down. The Impact Assessment Act also requires assessments to consider how projects will impact Indigenous rights. And while it doesn't require seeking Indigenous consent for projects, it does at least mention the United Nations Declaration on the Rights of Indigenous Peoples in the preamble. Also, for the first time in assessment history, it introduces a mandatory climate test. So in the assessment, and then also when making a decision, projects have to be assessed for the extent to which they will help or hinder Canada's ability to meet its international obligations. So for example, the Paris Agreement. That's a big step forward and should bring some consistency and some greater rigor into climate assessments. It also removes the standing test that was introduced in 2012. So now anybody can participate in assessments and pipeline reviews. And also the act requires the participation be meaningful rather than just a box to check. It also requires that decision makers give detailed reasons for their decisions, so the cabinet can't keep approving projects behind closed doors without showing how the project's impacts are justified. It's not perfect though. The Impact Assessment Act still allows the government to approve bad projects. It constrains some of the discretion to do so, but it doesn't remove it completely. As I mentioned, it fails to actually implement the United Nations Declaration on the Rights of Indigenous People, and it does not require that the federal government respect Indigenous rights and authority. And also, it's only going to apply to a handful of major projects like the current act does. So that means that the public isn't going to have an automatic right to participate in assessments of smaller projects, and that it's likely that a lot of cumulative effects are going to go unaddressed. So the bill also introduces a new Canadian Energy Regulator Act. This act makes considerable improvements to the National Energy Regulator. It renames the National Energy Board the Canadian Energy Regulator, and it introduces a number of accountability measures. So for one, it separates the regulator into board members who are responsible for the governance of the regulator, and then commissioners who have the responsibility for conducting hearings, issuing certificates, and regulating energy projects. It also introduces a climate test, the same one we see in the Impact Assessment Act, so assessing projects for the extent to which they'll impact Canada's ability or help Canada's ability to meet its international climate obligations and other environmental obligations. It also removes the standing test, so anyone who wants to have a say in a pipeline review can do so. It's not perfect though. It still restricts the public's ability to challenge decisions, and it keeps decisions about whether to approve pipelines in the hands of the federal cabinet, meaning that decisions on these important projects will continue to be political rather than based in science and fact and Indigenous knowledge. It also still allows the regulator to decide to not assess the upstream and downstream activities and effects of projects, which has been a major problem to date and will probably continue to do so. It'll allow the regulator to only look at the narrow direct effects of pipelines rather than all of the related greenhouse gas emissions that result from pipelines. And then finally, as I mentioned, it renames the Navigation Protection Act the Canadian Navigable Waters Act. and introduces a few modest improvements. The changes to the Navigation Protection Act are the most disappointing in the bill. Contrary to the mandate that was given to the Minister of Transport, Bill C-69 does not restore all of the lost protections that occurred in 2012. Instead, it actually keeps the system of only giving full protection to waters that are listed in a schedule to the Act. It does introduce a new requirement that all projects that are designated as quote-unquote major projects have to obtain a permit if they're constructed on any waterway, not just on scheduled waters. But for non-major projects, it's going to be up to the public and Indigenous peoples to prove that a project or activity impedes their navigation and fight for their right to continue to navigate that waterway. And probably most importantly, Bill C-69 doesn't actually list environment as among the things that Transport Canada has to consider when deciding to issue a permit. So as part of the justification for leaving the environment out of the Canadian Navigable Waters Act, the government has said that the Impact Assessment Act will capture the environmental effects of major projects, and the Canadian Navigable Waters Act is supposed to act as a safety net for capturing smaller projects. However, if the Navigable Waters Act doesn't consider environmental issues, then it cannot be that safety net that we need. So without the environment being considered in the Navigable Waters Act, a lot of important cumulative effects of smaller projects are likely to go unaddressed. So overall, Bill C-69 does introduce a number of improvements, and probably unsurprisingly, it has gotten a lot of pushback from industry. That pushback has been extreme, and particularly coming out of the oil and gas industry, who are being backed by provinces like Alberta and Saskatchewan, who are calling for the government to leave environmental protection or lack of environmental protection up to the provinces. So some of the things that industry is asking for are for the Senate to remove climate, sustainability, and gender analysis from the bill entirely so that their projects don't have to be accountable for those important impacts. They're also looking to restore some of the powers of the regulators, who have proven themselves to not be up to the job of rigorous assessment, and they want to allow authorities to be able to rule that upstream and downstream effects in impact assessments, not just in the smaller pipeline reviews that will be done by the regulator. They want to make those broader impacts off the table. And finally, they're asking for ultimate overall timelines for the assessments in order to help ram their projects through more quickly. These timelines could make it impossible for the government to respect Indigenous rights and authority and ensure that the effects of major projects like oil sands pipelines that can cross provincial and multiple Indigenous boundaries are properly assessed. So what you can do: get involved in the Senate hearings. The Senate really needs to hear from Canadians that the environment matters to them. The committee that is studying the bill in the Senate has heard from a lot of opponents to the bill. So we're really encouraging you to write to the Senate about your support for the bill, any improvements you'd like to see to it, and also ask to appear before them when it's on its tour. So again, Vancouver will be on April 8th. And there's the email address that you can send your request and any written submissions to. I'm just going to spend a few more minutes talking about some of the things that you might want to say about the bill. As I said, it's not perfect. It falls far short of the recommendations made by the expert panel that reviewed Canada's environmental assessment processes, but it's still a considerable improvement over what we have, and we're not likely to have this chance again for quite some time. So Canadians care deeply about the environment, their communities, and climate, and we can't keep letting big industry lobby government into weakening our environmental laws in order to fast-track harmful projects. So Bill C-69 is an improvement because it's going to give decision makers more information about a broader range of possible effects, things like effects on communities, effects on health, and economic effects, in order to better ensure that decisions consider all the relevant information and also are based on science and Indigenous knowledge rather than politics. The public really deserves to be heard on environmental issues that affect them, and this bill helps do that. Impact assessment is the best tool we have for doing that, and removing the standing test is a huge improvement over the status quo. So just in a nutshell, I think the Senate really needs to hear that we need strong environmental laws to protect Canadians and our environment. Things specifically that you might want to ask for to improve the bill, adding in a mandatory bottom line that would prevent decision makers from approving projects that would hinder our ability to meet our climate commitments, or projects that are unsustainable, would go a long way to actually achieving the sustainability focus of the Act and purpose of the Act. Also, don't give pipelines an easier ride. One of the things that Bill C-69 does is for assessments of pipeline projects, their timelines are about half the time as other projects that go through a review panel. So pipelines should have the same timelines as other projects, especially considering how long and complicated and how much risk can be involved with them. Requiring the Canadian Navigable Waters Act to consider environmental effects so that it can be that safety net that we really need. And then also just send the message that we need to keep industry's short-term economic interests from continuing to trump environmental and community needs. And then finally, one other area that the bill could be improved in is depoliticizing to some degree pipeline decision-making by allowing the new Canadian energy regulator to say no to pipelines instead of all decisions coming out of the federal cabinet. But above all else, the ultimate message that the Senate really needs to hear is do not weaken Bill C-69. So on that note, I'm going to pass the presentation over to Hugh, and then we will take questions and talk about how you can be involved in the Senate process after he has presented. Thank you.
Sorry, Hugh, you're still muted.
I was sure I had unmuted. Sorry about that. Thanks, Alexis and Anna. As I was just saying, I'm a lawyer who's been working with West Coast and some of the other environmental groups on this reform effort for the last couple of years, particularly with government relations and parliamentary relations advice. And so I'm going to build on what Anna has done and give a bit of the lay of the land, give a sense of the urgency and the timing of the way things are moving, a little more on what is needed and why, building on what Anna just told you, and I'm sure we can fill in any critical gaps I may have left unfilled through your questions later. So I'll work through this as quickly as I can. So the Senate committee has been, and I'll go over the overall process in a moment, but they've held 8 meetings so far, and this is just the lead up to when they come and see you folks in Vancouver. They've heard on the first day of testimony from federal officials, which is very useful because those are the officials who in large part know the design and the intention of various parts of the bill, and so they heard testimony from those officials. They heard a day of testimony from regulatory bodies, so the National Energy Board, the Nuclear Safety Commission, as well as the regulatory body in Nunavut and the Alberta Energy Regulator on that day. They've also heard, importantly, from 11 industry associations, as well as 2 private sector consulting firms, Stantec and Golder, over about 6 of those meetings. And they've also heard from either the Premier, a senior minister, or senior official from 6 different provinces, plus Nunavut. And with the exception of BC and to some extent Nunavut, as well as those 2 consulting firms, the views of those provinces that have asked to appear and the committee has heard from have been generally hostile to Bill C-69 or in more or less opposed in fairly critical ways. just building a bit on what Anna said, generally the nature of the opposition is that economic considerations need to be more prominent in impact assessment. There are too many of what they refer to as policy considerations in project EAs. Big one, for example, is that proponents feel that their projects will be slowed, delayed, or blocked by talking about climate change. Thirdly, and again, these are very general, too much discretion for Minister of Environment or for Cabinet to stop projects. And finally, as Anna said, in general, that the timelines are too long and that this will, quote unquote, kill projects and investment in Canada. I think those give you, including my added comment there, a flavor of the opposition in general. So very quickly, as most bills like Bill C-69 do, it was introduced by the Minister of the Environment in February 2018. It went through the various stages of the House of Commons and was referred to the Senate last June. Due to the opposition taking its time to using normal Senate procedures to not help in speeding the bill through, second reading took over 12 weeks, but just 12 sitting days over that period to be completed. And basically, debate general notion of the bill, and it was up to the opposition to say we want to speak tomorrow or no, we don't want to speak until next week, and that delayed. That's what took so long. Not unusual, but took some time. The result of that is that the bill, as is usual, once second reading was over, was referred to the Standing Senate Committee on Energy, the Environment and Natural Resources in December, just before the Senate rose for its Christmas break. And then those 9 meetings that I mentioned, well, I think I mentioned 8, but one additional one, were held from February 5th until just last week. And so that brings us to where we are now. So the bill is in the possession of the committee. There are 13 weeks until June 28, which the parliamentary calendar has Parliament scheduled to rise for the summer on June 28. Excuse me. So far, I've told you essentially all of the witnesses that have been heard. There have been no public interest witnesses or other witnesses other than those I mentioned. However, next week, some of the environmental groups and environmental law experts, professors, have been invited to speak, as well as the Federation of Canadian Municipalities, an engineering association, and the Native Women's Association. Pardon me. And that takes us to the tour, which will be visiting those 9 cities listed, including the first visit, which is in your fair city, for those of you in Vancouver, on April 8th. What we expect to see from what we've heard so far is that they're going to hold pretty long days in each of those 9 cities, 6 hours per location, and witnesses will be sitting on small panels of perhaps, so far as we know, 2 or 3 people. We'll just speak for 5 minutes, which has been the process in Ottawa so far as well. And then the senators in turn ask the panelists questions. But Anna reminded me that people might want to know, why is this tour happening in the first place? And we've learned through this that while Senate committees often travel, it's much less common up until now for committees to travel when they're studying legislation like this. Normally they do that from Ottawa, they call witnesses in and hear from them. But there was so much opposition, and I'll come to that in a moment, but from the official opposition, as well as the oil and gas and other industries, to this tour, to this bill, and raising a lot of misinformation or half-truths or untruths about what is in and is not in the bill and what the bill would do. They were able to build up a momentum that convinced the senators that they needed to go out and see Canadians or go visit those cities, in spite of the fact that, for example, they'll be in 2 places in Alberta just a week before the election in Alberta. So perhaps questionable that they're going to be productive and perhaps otherwise may foment a lot of polarization that already exists. So it's been that general opposition that's caused this to happen. And so we are concerned, but hoping to get voices in favor of the bill to speak in favor of it. Just an overview of the process with a couple more slides. The Senate committee decided that it would report Bill C-69 back to the Senate by May 9. And so what it has to do before then is once it's heard from witnesses, or indeed now while it's hearing from witnesses, senators have to decide which amendments they want to propose. They'll submit those to the committee clerk, and after the witnesses are heard, the committee will resume in Ottawa and hold a number of meetings where they'll go through the bill clause by clause and amend parts of the bill perhaps. And so in general, we're resisting a lot of the kinds of amendments that we've spoken about very generally on this webinar so far, and urging the committee to, generally speaking, keep the bill in the condition that it's in and pass it. I can come back to this, and what we hope to see as well is that the bill would pass, get out of the committee, be reported to the Senate without a lot of changes. If there are amendments proposed by Senate, as you'll remember from the cannabis bill and the assisted dying bill, any changes have to go back to the House of Commons, where ultimately the cabinet decides what it will accept or not, and it can use its majority in the House to support or vote down various amendments. Then if there are still some amendments that the House has refused, the bill goes back to the Senate for it to decide whether it wants to push on any of those remaining amendments. So far we haven't seen it much, but there could be a bit of ping pong back and forth between the 2 houses. And so that's why I've included at the bottom of this slide just the fact that additional days could be added beyond June 28, but at the moment that's when both houses are scheduled to rise for the summer. And and of course the election is to be called in October. So we'd like to see the bill pass through both houses, given royal assent by the Governor General, and then it's up to Cabinet to bring the bill into force on a later date, but we'd like that to happen before the election is called. And so this slide briefly just explains, I think, everything that I've just mentioned, except for the third last bullet there. Senators can also make amendments at third reading once the bill goes back to the Senate, full Senate. And so I just mentioned that because your views and wishes expressed to the Senate will help dampen a lot of amendments that will go in the wrong direction that might be introduced in the Senate committee or in the full Senate. So I think those are the main points I wanted to make, and there are a lot of moving parts, so perhaps things that I've left out we can address through your questions. So I'll leave it there, and thanks very much again.
Right. So if anyone has questions, you can feel free to type them into the Q&A window, and then we can address them out loud, or you can click the little raise your hand button, and then we can allow you to unmute yourself so that you can ask questions out loud.
Somebody asked me to leave my last slide up, so I'll do that, and maybe you can indicate, or I'll put it up and see if that's something you wanted to see again. I can put it up for a minute if that's okay.
And Hugh, we've just had a question looking for tour dates.
Oh yeah. Okay.
Do you have those offhand?
I do, yeah.
It looks like looking for Anna's last slide.
Thank you. Okay, I won't share mine. While Anna's digging that up, the dates are Monday, as you know, April 8th, Vancouver. The following day, the 9th, is Calgary. And we understand they may be going to Calgary and also to a reserve just outside Calgary, although we're not sure about that. Wednesday, the 10th, is Fort McMurray. Thursday, the 11th, is Saskatoon. And Friday, the 12th, Winnipeg. So that's the second week of April. And then the Eastern tour follows Easter Monday. So on April 23rd, the Tuesday, is St. John's, Newfoundland and Labrador. The 24th is Halifax. The 25th is St. John, New Brunswick. And the 26th is Quebec City.
Just having some technical difficulties, but I'm also going to get up a sample letter that folks can use to send to the Senate. So when sending in any submissions, they don't have to be long, they don't have to be technical. You know, we really just encourage you to, as I said before, tell the Senate that strong environmental laws matter to Canadians, because the discourse around this bill has predominantly been about how industry needs certainty and why the short-term economic needs of major businesses are more important than any other consideration. So here's the email address to the Senate. You might want to include a little title, for example, submission to the Senate Standing Committee. Give a little introduction, an opening, thank you for this opportunity. If you have any experience in environmental assessment, if you have participated in one before, or you've been a consultant for one, that's a good time to say that so that the Senate knows where you're coming from and where your experience is based on. Talk a bit about just why strong environmental laws matter, why you support Bill C-69, and then if you want any improvements that can be made. And as I said in the chat box, I can share my presentation after this webinar, and we'll also be sharing the video. So you can always go back to these resources.
Just a couple of comments. Anna, I'm not sure if you said this, but I think it's really great for people to give their own personal touch because it is, and not just seems, much more authentic for people to write those things that Anna suggests in their own words. And secondly, Anna, I'm not sure if you or Alexis have provided an email address or something. It would be helpful for us to have those, if you could copy us with your letters so we know that you've submitted them. I'm not sure if you said that, but that would be great.
Yeah, and that's a really good point about the personal stories. I mean, I think environmental assessment and energy regulation tend to be very abstract things, and a lot of these senators aren't familiar with those processes. They know what it looks like on paper, but they don't know what people's experience is like when, for example, they're told they're not allowed to participate in a National Energy Board hearing on the Trans Mountain Pipeline, or when you participate in good faith in an assessment of a dam or a mine, and then you see that the decision has completely ignored all of the concerns that you've raised. And so I think it's critical that the Senate hear these stories so that they don't just keep hearing these lines parroted by industry over and over again that this is the No More Pipelines bill, or you know, this bill is really harming investor confidence. And of course, we know that saying that this bill will kill investment in Canada does more to undermine investor confidence than any piece of legislation ever will.
All right, I see one raised hand here. A question from Tony. Go ahead.
There we are. You got me?
Yep, we can hear you.
I mailed in a question earlier about the idea that, in fact, Kamloops apparently doesn't matter as far as meeting locations are concerned. We have spent the last 7 years fighting in an environmental assessment against the monster Ajax mine that they wanted to establish on the border of our town, quite frankly. And I see that I mean we're sitting here with 90,000 people. We have a very active environmental consciousness and council, by the way. Certainly a group that is very active against this Trans Mountain Pipeline issue. I'd like to know why Calgary and Fort McMurray, who are obviously and always have been pro-oil, pro-pipeline, pro-whatever, you know, they can do to sell their dirty oil everywhere around the world, and yet Kamloops has no say here whatsoever unless we're willing to spend the $500 to head off to Vancouver.
Yeah.
Maybe Hugh is the one I could answer that, or Anna, maybe you. I'm not just sure which. Is there any way of changing that and getting something happening in this local area?
You go ahead, Anna. I can follow up if I think.
Sure. At this stage, I don't think there's any chance in getting them to change their schedule. The Senate, in order to travel, had to go through a number of processes, a number of votes, both within their committee and beyond, to get the budget and the schedule for travel. So at this late date, I think that it's not going to happen anywhere else. I think it's a great comment that they appear to have chosen communities where they're most likely to receive opposition to the bill, as opposed to hear from folks who support strong environmental laws. I do think, though, that the Senate will pay for any travel costs to come down to Vancouver or to the other cities that they're traveling to. So if you wanted to make that trip from Kamloops, almost certainly the Treasury Board has rules that allow people to travel from their home city to where the Senate is. And so almost certainly that would cover your travel from Kamloops down to Vancouver. So I would email the Senate and ask them that. I think you're right. It's really too bad that, and we actually did recommend that they go to Kamloops as well as Fort St. John, because both of those communities have had such a huge amount of experience with bad assessments. Yes. But to no avail.
Okay, well, I guess I can appreciate that. I'm just a little bit, well, I'm a lot upset the fact that these people did not look at these issues before they decided on their very restrictive list of cities that would be involved. We have had some success in this kind of thing before when we had the Site C review. They were going to meet everywhere else in BC except Kamloops. So we, you know, bitched and complained, and eventually we did get them to come here. So I was thinking that, you know, maybe they would be open enough to hear from First Nations here in Kamloops, who have in some way, they have given local permission, but the hereditary chiefs and powers and so on have not for this Kinder Morgan pipeline. And it's pretty disturbing to see government just say, well, you know, you guys don't count. So anyways, I appreciate your comments, and I guess if we're being recorded, so the comment is there, and the Senate can read it or not. Thank you.
Thanks.
Yeah, thanks. As I'll just quickly add, as Anna says, we made a similar case about where we thought the committee should travel. And needless to say, there are senators from various groups in various parts of the country all vying for their places that they wanted to go. And we were, you know, none of us could really effectively intervene in that inside discussion. But really what's most important is that we keep our eye on the prize, which is not so much the tour, but making sure that the bill passes in a good shape. So that's what we're trying to focus on.
Could I make one more little comment? Hello?
Yes.
You mentioned earlier the hopeful adoption of the UNDRIP commitment from the United Nations. Just recently, we had Russell Diabo in town giving a quite a long dissertation on the colonialization and that sort of thing. Russell, of course, was a friend of Art Manuel, who was very much a supporter of UNDRIP. But Russell said something about the very last phrase that was added to UNDRIP by the Canadian government, which makes it impossible, apparently, to have any kind of alteration in UNDRIP itself. And it is a step backwards as far as Russell was concerned. I don't necessarily, I think you should read that last phrase and try and understand that Canada actually was trying to limit the effect of the United Nations Declaration.
Yeah, thanks for that. I mean, as an international instrument, it's not binding on the government of Canada. So what we're looking for, of course, is meaningful implementation of the provisions of UNDRIP that, you know, would be relevant. For example, in an impact assessment, we're really looking for language in there that would require the government to seek and obtain the consent of Indigenous peoples. Yeah. And especially not just in the final decision-making stage, which is where this, you know, the notion of free, prior, and informed consent tends to get caught up. But, you know, in the early planning phase, which we didn't cover in this webinar, but which is a really also important introduction to Bill C-69. It seeks to bring Indigenous peoples to the table much earlier before the assessment starts, along with the public and along with provincial governments, to help identify what the key issues are, what information, including Indigenous knowledge, will be needed. The Act does require that assessments consider Indigenous knowledge. And so I think the hope is that through having those different authorities, including Indigenous authorities at the table in the beginning, processes can be built that will better enable consent to be achieved. But of course, as I said, where the Act falls down is it doesn't require the consent.
Understood. Okay. Okay, thank you very much. I appreciate the webinar entirely, guys. Thank you.
Thank you.
Bye-bye.
Any other questions from folks out there interested in engaging? Should we get a show of hands for who's going to appear before the Senate? They're a friendly bunch.
Maybe I can just say while we're waiting that something Anna said makes me think that a lot of what's good about the proposed Impact Assessment Act is that it's enabling a lot of things to happen. And Anna mentioned the very important planning phase. And I mentioned some of the opposition is coming from provinces who fear that, and this is an old story, that the bill will, or the Impact Assessment Act will intrude on provincial jurisdiction. Well, that's been proven in the courts time and again not to be the case. The feds have their jurisdiction, the provinces have theirs. And what I mean when I say enabling is that provinces and the feds need to come to the table, negotiate agreements where necessary to cooperate in assessments, but also come to that planning phase and with all of the relevant parties there, including the proponent and the public, and sort out issues earlier. And that's all part of the public trust recipe that we're trying to correct that's been badly damaged through the experience of the current law.
And I just see that there was a question about how do you request to speak on the 26th? So I presume that means in Quebec City. So all you have to do is email the Senate committee, which I'll bring that back up. So you just send an email to that address, enev@sen.parle.gc.ca. It's really simple. You just have to say, hi, I would like to appear before the Senate committee when it will be in such and such city on such and such date. You may want to include a little note about, what you can bring to the table, whether it's that you're a concerned citizen who wants to support the climate provisions, or you have experience, for example, maybe in the Energy East pipeline. You don't have to do that though. They should be going on for many hours. So, there'll be room in each city for probably up to potentially 20 people to present. So all you have to do is send that email and make sure that your voice gets heard.
And we thought that there, sorry, Alexis, I was just going to say, we thought there might be room for other types of fora that the committee might hold, opportunities for people to be heard, like a town hall type of format. But as far as we know, they're not doing that.
We have another question here about how the bill is a positive step for the climate. So if anyone wants to take that one.
Well, I had suggested that questioner, Corinne Pellissier, might want to speak up about that. Corinne knows as much or more about climate as any of us. Corinne, are you there? Or should we take a go?
She can't find where to talk, but we'll give you the talking.
Yep, I will unmute you just a sec.
Hello?
There
you are.
And we can just say Corinne Pellissier is a lawyer with the Quebec Environmental Law Center here in Montreal, where I happen to be.
Yeah, hello. So I guess on the climate front, I'm going to answer my own question. Previous Environmental Assessment Act never mentioned the climate, even if I think a lot of environmental lawyers and activists have been saying that it's possible and should be required to consider climate impacts under the current law. It's been always a constant battles for pipeline assessments, LNG assessments, and the like. And Bill C-69 for the first time mentions the word climate in an Environmental Assessment Act. And it says that every project, decisions to be taken on every project will have to consider whether the project hinders or contributes to Canada meeting its climate commitments. So it doesn't require the project to help Canada meet its commitments, but it at least requires the question to be considered, and therefore is a pretty positive step that is worth defending. That's it for me.
Yeah, that's a great point, Corinne. And I think one of the other real improvements it's made is when climate was assessed under the Canadian Environmental Assessment Act 2012, and before that even under the original CIA, reviewing authorities like the agency, the National Energy Board panels really struggled with how to contextualize emissions. So if you have a project that's going to release 5 or 10 megatons of GHG emissions per year, the test under the current and the previous act was, whether the project would result in significant adverse impacts and whether those impacts were justified in the circumstances. And that was a real struggle to determine whether or not a certain amount of GHG emissions was significant. And so experts have been calling for years now for, instead of trying to figure out the significance of climate, to use things like the Paris Agreement and the Pan-Canadian Framework and our 2050 decarbonization goals, and even carbon budgets to go more into smaller pieces as a proxy for significance. So in other words, instead of trying to determine whether or not 10 emissions is a lot, or would the impacts of those emissions be significant, to look at whether or not the project helps or hinders our ability to meet Canada's international obligations on climate and then our domestic policy. I think that will make it much easier and clearer for the public and for decision makers to understand the implications of climate. And really at its core, the pushback that we're seeing from the oil and gas industry is an attack on climate regulation. They're nervous that their projects will look bad when assessed under this act, and so they don't want those impacts to be understood or to be made public.
Okay, we have another question here for clarification. If the new pipeline regulator is allowed to exclude upstream emissions, how does that square with the requirement to consider how the project would impact Canada's climate commitments?
Yeah, it's a great question, and it doesn't square with the requirement also in the Canadian Energy Regulator Act to consider cumulative effects. So I think in a nutshell, it will allow the regulator to look only at the narrow direct effects of projects like pipelines, and that won't give decision makers the information they need to understand whether or not the project will help or hinder our ability to meet our Paris Agreement. Because of course pipelines enable upstream activities and they bring oil to places to burn downstream. And so if we're not looking at all of the related emissions that flow or that are emitted as a result of a pipeline, then we're not properly assessing that project's contribution to GHG emissions. So the act is a bit contradictory in those two senses. And as a result of that, there may be increases in litigation around what the language of directly related to the project means. Some academics have weighed in already, saying that probably the courts would interpret the act as requiring the upstream and downstream greenhouse gas emissions to be assessed, even though it says directly affected. We would recommend just removing that language to make it crystal clear and consistent across the board.
All right, any other questions out there? Oh, I see another hand up from Tony. Okay, go ahead.
Maybe still muted.
There we are.
There you go.
I wanted to, and thank you for the second opportunity here. It's probably not all that good to do that, but nonetheless, I want to explain also the fact that while this bill has made some steps back to what some of the issues we had, like 10 years ago, when it was a viable act, there are downstream effects here that are not considered, again, as you say earlier, that have actually nothing to do with the pipeline itself, but indirect things such as an additional 300 tankers coming into the Salish Sea. Each one of them perhaps belching, I think it was the Pembina Institute that said each one of those big tankers will put out equivalent emissions to over 1 million automobiles on the land. 300 times, 1 million automobiles, that's a lot of additional emissions per year that should be considered. The other consideration, of course, is the potential wiping out or extrapolation of the orca in the Salish Sea, who simply cannot stand the additional noise and clutter. We've had other whale strikes in the Salish Sea as well. Apparently, these things don't matter to the folks in Ottawa.
Yeah, so that's a really interesting point. So one of the amendments that the Canadian Association of Petroleum Producers and the Canadian Energy Pipeline Association want to the Impact Assessment Act portion of the bill is a provision that would allow the agency to scope what components of the project are subject to the assessment. So in other words, they're looking to enable the new Impact Assessment Agency to scope out components of the project. And I believe that they're asking for that because of the Federal Court of Appeal decision on the Trans Mountain Pipeline, where the National Energy Board failed to review marine shipping, and the court said that that was a mistake and ordered them to take another looking at marine shipping this time, including it in the assessment. And so I think what CAP and SEPA are trying to do is to make it legal for authorities to scope out those downstream impacts and effects. And again, of course, that would be completely contrary to the provisions requiring us to assess implications on the Paris Agreement and also to look at broader cumulative effects. So I think that, and because it's a technical argument, and they've been very compelling in their reasons, saying that it would provide certainty to industry, which is something that the Senate cares deeply about. It's especially important that we push back against amendments like that so that all of the important effects of projects can be on the table so that decision makers have all the information they need to determine whether a project is in the public interest and sustainable.
Also, this discussion really highlights, it's very helpful because on the climate considerations and on Tony's comment about the tankers and Anna's response, it all just underscores, clearly we cannot have everything, and we haven't nearly achieved the things that we wanted here, but this is a very rare opportunity for us to hold the line and, as Tony suggested, improve on what we have now. And that's really why we need as many voices as we can pushing in that direction. It's not where we want to go, but it's certainly where we need to go with this bill as at least a starting point and end the period of the Canadian Environmental Assessment Act 2012.
Thanks, Hugh. So we've got just about 2 minutes left. I don't see any other questions right now. Oh, there's one more hand up. All right, Chris, you now have the ability to speak.
Yeah, I've got the unmute.
There you go.
The whole context of this must tie into cumulative effects and these other things that we're talking about. Just saying, let's get Bill C-69 through, is there a parallel process and comment say that this is insufficient in these areas, and we are in fact clouding the issue of long-term stability in the environment by doing half measures? I'm sorry I'm not being very explicit here, but you may get the message that you people are already beating the drum that the legislative process is seriously insufficient.
Yeah, it's a really good point. There have been some groups, and also, Elizabeth May from the Green Party, who have really staunchly opposed Bill C-69 because we could be doing better. I think, as I mentioned earlier, just because we've decided to support it because of the political reality that if we don't and it doesn't pass, then we're stuck with CA 2012. And I think that that's a decision that folks need to make for themselves. But you mentioned cumulative effects, and that's another another area where the bill is moderately better than what we currently have. So Bill C-69, and there wasn't really time in the webinar to address all of the things that it does, but it does introduce a few provisions that would allow the minister to conduct regional assessments and strategic assessments to address broader cumulative effects, look at the big picture, ideally to do that in a way that would result in coming up with development scenarios so that we actually plan development in a region instead of just constantly responding to proposals. Those provisions aren't mandatory, so they're not terrific, but along with the bill, in last year's budget, the federal government provided $1 billion for implementation of the bill, including a package of money to roll out 5 pilot projects, 5 regional assessments. So the federal government is trying to work with provinces to identify key regions in order to start doing those bigger picture cumulative effects assessments. So I think we'll need to continue to hold their feet to the fire to make sure that they do a good job of those, but there's some, room for encouragement there.
Yes, in the forestry industry, they have annual allowable cuts, and I know that this is a controversial thing, but is that a precedent as to how a regional area has to collect not only new projects, but existing consumption into an overall strategy, which then has to be backed by law rather than the hand-to-mouth existence that we're faced with at the moment?
Yeah, you've hit the nail on the head. That's what, in an ideal world, a regional assessment would do. It would look at existing cumulative effects, it would look at alternative development scenarios, and it would come out with a plan for future development that would be sustainable, that would respect ecological limits, identify ecological limits, and then respect them. It's a little bit trickier in for the federal government because it's the provinces that have primary jurisdiction over natural resources, things like forestry, that do tend to make the greatest amount of cumulative effects. And so the feds haven't put anything into Bill C-69 that would require compliance with the outcomes of these regional assessments. So they're just going to be, at best, policy documents that will be considered in project level decision making.
Thank you.
So maybe just in the last couple of minutes, we'll make one last plug for folks to get involved. We've had some great questions. So obviously there are people on this webinar who know quite a lot about environmental decision making and assessment, and the Senate really needs to hear from you about what's broken, about what could be fixed, and why Bill C-69 is an improvement and how it could be even further strengthened. So send them in your emails, your written briefs. Come down to Vancouver on the 8th, or to any of the other cities it's going to across Canada in April.
And I've also made a note in the comments there to email us with any questions or follow-up concerns at communications@wcel.org, and we can get those questions to the right person. And if you are sending your submissions, we encourage you to copy us on those as well. All right. I guess if we've got no other comments, we can wrap it up. And thank you very much for everyone for joining us.
Yes. Thanks all.
Thanks, everyone.
And thanks for your great questions. And thank you, Alexis, for guiding us through this webinar.
Sounds good. All right. Take care, everyone.
Bye now.